Ladies and gentlemen, dear colleagues, dear students, on behalf of Tilburg Law School, I all bid you a very warm welcome to our annual Montesquieu lecture. The Montesquieu lectures, named after Montesquieu, who is also the person to whom we named our building, is an initiative we started, I think, now 6-7 years ago, when we moved to the new building and when we named it after Montesquieu. It's an annual tradition now, and this year is a bit of a special occasion because we have combined it with the Global Law Conference and, more importantly, I must say, with the founding of the Law School's Global League, which hours ago took place here at our campus in Tilburg. An initiative we're very proud that we are part of that, to be part of it, and that we actually have made that foundation of the league here on our campus. The people sitting in the first rows, except of the speaker Neil Walker, present here today, are the representatives of 16 schools from all over the world, from all continents, who have decided to join forces in this league. I'm going to very brief say a few things about this initiative. It's an initiative that was pretty much cooked up in a room in São Paulo when a Tilburg Law School delegation 3 years ago visited Fundação Getúlio Vargas Law School in São Paulo. And we jointly had this idea that, of course, globalization is an extremely important phenomenon, extremely important process, event that is profoundly going to change the way, is profoundly changing and going to change the way we look at law, we practice law, we teach law, and as scholars we research law. And that, of course, it makes all sense as we are aware of that, as we are studying in this phenomenon in our different parts of the world, that it makes tremendous sense to start an initiative, as other initiatives will certainly start in the world, start an initiative to study that phenomenon on a global scale. And in a setting with law schools, we're now 16, 5 more are going to join in the next 2 weeks. We want to expand the league a little bit more to 25, maximum 30 members, in a league that is really globally balanced, that is not dominated by one legal culture, by one legal tradition. And in a way, we try to stimulate, in the end, bottom-up cooperation in education and in research between the faculty members of our schools, of course, also engaging and opening up to individual faculty members of other schools in the world. I won't say too much about it because I don't want to use up much time for the Montesquieu lecture, but I want again thank the 16 law schools here present for engaging in this adventure. The 5 who couldn't attend but are also on board, and particularly the dear colleagues of FGV São Paulo for starting this adventure with us a few years ago. Now I'm going to turn over the floor to Professor Willem Witteveen, who is actually a bit the founding father in our school of the Montesquieu lectures. Well, he is the founding father, not a bit, of these lectures. He's professor of jurisprudence and rhetoric, and he will speak for something like 20 minutes to introduce the whole idea of the Montesquieu lectures, and particularly introduce our guest of honor and guest speaker, Professor Neil Walker of Edinburgh. Thank you, Willem. You have the floor.
Je hebt mijn papieren meegenomen als ik jullie mee mag geven. Ladies and gentlemen, this is indeed already the 7th occasion for the Montesquieu lecture. We started out with Brian Tamanaha, who spoke about the dangers to the rule of law from legal instrumentalism. We had James Boyd White, expert in law and literature, talking about the ethics of being a lawyer. We had Tom Tyler, who knows why people obey the law and made us know why this is the case. We had, in a much larger venue, together with the Nexus Institute, Michael Ignatieff on big issues of war and peace. And then we had 2 speakers that are interesting for the topics of today. We had William Twining, who is deeply into the study of globalization and law. And then we had Aharon Barak, Israeli Supreme Court justice and scholar, who is studying the way judges develop the law. And we had discussions with him about how this common law approach could be replaced to European context and produced a book out of that. And these lectures have all been interdisciplinary approaches in the spirit of the founding father of these lectures, who was really Montesquieu. Montesquieu started, I think, comparative law. He started doing sociology. And this means that these lectures have to be interdisciplinary. And we are very happy indeed that this one today will be delivered by Neil Walker on Intimations of Global Law. And that will bring also a background of philosophy into our discussions. Okay, I'm going to say more about Neil Walker later on, but first my task is a different one. I want to say a little bit about the connection between today's topic and the Law School's Global League Conference that has been held with great success already today. And what I want to do by way of an introduction is take some time for a historical excursion. I'm going to take you back to the time of Montesquieu and ask, what meaning could the question of global law have for Montesquieu himself? Was there even such a thing as global law in the 18th century? Or is it a completely new phenomenon depending on the economical, technological and political developments of the late 20th century and beyond? And I do not intend this historical excursion to be simply a nice piece of embellishment of a program that otherwise is highly serious, as the past is so often seen as a place where they did things differently anyway, and that has no connection anymore with the postmodern world we live in. On the contrary, I believe that by momentarily disconnecting ourselves from present concerns and dispositions and entering imaginatively into the worldview and the theoretical framework of classical thinkers about law and society, like Montesquieu, we can learn something that is unique and special. We can learn to see through the eyes of a great scholar who was working in a different context, who was differently situated, and by doing so, hopefully, we can see some of today's trends with a fresh eye. So, what was global law in Montesquieu's world? There is a simple answer to that question. There already existed the jus gentium, a natural law. Regius, for instance, the Dutch legal scholar, points out that everywhere on earth, when people are trading with each other and reach agreement, this agreement is binding upon them, no matter what the cultural differences between them are. But Montesquieu, in his big book on the spirit of the laws, is not deeply interested at all in this as a universal mechanism, and he also rejects another thinker, Hobbes, with his ideas about the laws of nature. Now I'm going to quote Montesquieu. The laws of nature derive uniquely from the constitution of our being. To know them well, one must consider a man before the establishment of societies. The laws he would receive in such a state will be the laws of nature. Such a man would at first feel only his weakness. His timidity would be extreme. And as for evidence, savages have been found in forests. Everything makes them tremble. Everything makes them flee. In this state, each feels himself inferior. He scarcely feels himself unequal. Such men would not seek to attack one another, and peace will be the first natural law. Hobbes gives men the desire to subjugate one another, but this is not reasonable. The idea of empire and domination is so complex and depends on so many other ideas that it would not be the one they would first have. Montesquieu is much more interested in societies when they have already been constituted, and I quote again. As soon as men are in society, they lose their feeling of weakness. The equality that was among them ceases, and the state of war begins. Each particular society comes to feel its strength, producing a state of war among nations. The individuals within each society begin to feel their strengths. They seek to turn to their favor the principal advantages of the society, which brings about a state of war among them. These two sorts of states of war bring about the establishment of laws among men. Considered as inhabitants of a planet so large that different peoples are necessary to have laws bearing on the relation that these people have with one another, and this is the right of nations. So much from Montesquieu. So his scheme, simplified a little bit, is like this. Before political societies, people aspire to peace. With the advent of the state comes a state of war. It has to be tamed by laws and institutions within and between states. And then also the complex ideas of empire and domination come into the world. Does empire respect the dictates of natural law? Does it acknowledge that there are forms of cooperation, such as that of contract law with the principle of pacta sunt servanda, that are universal and pertain also in context between people who do not know each other's language and culture? Montesquieu, I suppose, would, on empirical reasons, be very skeptical about this. And he is right to be so. If we follow, for instance, the account given by Stephen Greenblatt in his book Marvelous Possessions, about the way trading and conquering missions from the Western world treated the Indians they found in remote parts of the globe after their long seafaring trips. Allow me an excursion within this excursion on Montesquieu, because the story Greenblatt tells is so interesting and so much a global law story. Jacques Cartier, a merchant landing in the Gulf of St. Lawrence, sees the Indians holding up furs on sticks. And he thinks they are not enemies, they want to make a proposal to barter. So the next day he sends 2 men on shore with some knives and other iron goods and a red cap to give to their chief. And then Cartier writes in his journal, "The savages showed a marvelously great pleasure in possessing, obtaining these iron wares and other commodities, dancing and going through many ceremonies and throwing salt water over their heads with their hands." And what then follows is an extreme act of exchange in which the natives barter all they have and all they have on them, so that they go back to the forest completely naked. Trading relations have been established, and so we would now expect that Grotius' natural law scenario would come into play, in which contracts are created and understood by both sides to be binding, so that you can have further useful bartering relations. But no such thing occurs. Cartier interprets the performance of the naked Indians as an indication that they are ready to be converted to Christianity. After all, they have divested themselves of their beliefs together with all of their belongings. And then he picks up some of the words he hears them say and uses these words, which he cannot translate, to name them, and in that way to baptize them in a way and introduce them to the world of nations. And Greenblatt discerns a hidden logic in this strange sequence of events that differs markedly from natural law accounts. And I'm quoting Greenblatt. Cartier's reading of the native responses to barter has led him to the conclusion that they would be easy to convert. The task of conversion will necessitate the learning of their language, which here begins with the notation of their words, and the inscription of Indian words in European letters is paradoxically a step toward the renaming, the linguistic appropriation of the land. The act of stealing the land from them is then not very far off. And Greenblatt gives another example of the mismatch of communication in these kinds of incidents, which lead to changes in rule and in law. He quotes an account by one of the colonizers of the Maya people, who tells that when the Spaniards asked how their land was called, the Indian chief said, "Uik atan," which means, "I do not understand you." The Spaniard let it be written down that the land was called Yucatan. And in this way, the Maya expression of incomprehension became the colonial name of the land that is wrested from them, concludes Greenblatt. So we can see that imperialism it begins in complex ideas, with the Western conception claiming to be the truly global one, repressing what there could possibly have been of a natural law of peoples everywhere around. Montesquieu does not follow this route. He finds another way of imagining global law. And he does this by carving the world up into regimes, each with their own integrity, their own social logic, their own functionality. And I suppose we all remember them. There is one kind of unfree regime called despotism, and there are 3 very different kinds of regimes in which liberty is viable: direct democracy, representative democracy, and monarchy. the regime of France that Montesquieu favored. But these regimes are not separate empirical entities like bounded nation states. They are ideal types that are historically filled in certain ways, and one is living in one particular regime, one has to have a look at the whole panorama of regimes in order to make decisions about the way your own regime is going to function well, meeting the needs of its inhabitants. So the art of statecraft is crucial. Montesquieu imagines the laws as an artificial creation, almost a complex work of art, serving to provide the normative infrastructure of social, economic, religious and political life. But this is not a closed system. At first, Montesquieu uses his dark vision of the terrors of despotism, using charged interpretations of Muslim states like Turkey, to create a verbal counterpoint to the free regimes, and as a warning not to let the institutions of your free state degenerate in the direction of despotism. And he is here using all kinds of overblown ideas of what these nations are. He is here, in fact, exploiting a form of Orientalism that is quite prevalent in his culture, and which he himself had been treating in a much more subtle and critical way in his earlier book, Persian Letters, which shows that in many respects Muslim culture is superior to French culture. But here he uses biased accounts. And then much later on in the work, and also much later on in time, because he worked for a very long time on the spirit of the laws, he gets interested in other regimes that are also despotic in some aspects, but liberal in others, like Japan, like China. And then he becomes this nuanced proto-sociologist who makes distinctions within the class of liberal regimes in order to show that here there is integrity of culture as well, so that his thinking about global law is not one of a kind, but shows a kind of rift. Well, when we now get a little closer to how Montesquieu viewed the world, we may wonder what we can take from his vision to today's world, which is in many respects so utterly different. And then what is striking first, I think, is the limits of his and of our knowledge of the various legal orders that make up a world we can never know in its entirety, even with our most advanced information technology. Montesquieu had never been to China. He had never been to Japan. He trusted books compiled by scholarly missionaries who had traveled there. We can take a plane to China. We can take a plane to Japan. But when Western scholars do not know the language, the culture, the history, the practices, they are bound to get the wrong kind of impression. And in dealing with law from another culture, we come up against the same kind of surprises as Montesquieu came up when he tried to extend his analysis from Turkey and Persia to the Far East. Patrick Glenn has charted in his book Legal Traditions of the World a number of non-Western legal traditions, such as the Muslim tradition, the Jewish tradition, the Hindu tradition, etc., that are highly relevant in the context of global law, but they are bound to be impenetrable to those who do not know the language, the history, the culture, and the practices that these traditions engendered. What we can learn from Montesquieu is a lesson that Glenn practices to be prepared for surprises and to be respectful of everything that is not immediately clear, that does not immediately fit into the categories of Western law. And then there's a second thing. Montesquieu's interesting strategy of distinguishing between three sorts of regimes in which liberty is possible. Isn't that a lot more sophisticated than the strategy of exporting one kind of democracy and one type of rule of law by military means, as has been an American project supported by the Netherlands in the past half century? Unless we respect local knowledge, forms of deliberation that do not look like those at home, ways of reaching decisions that are not related to elections, and ask what makes regimes like this work, and ask how they can realize perhaps not only some kind of freedom, but other values as well. Unless we start doing that, we will not have progressed much beyond the time of Montesquieu. A regime that we envision as part of the global order is never a permanent part of the world, but is an ideal type that can be interpreted differently and that can lose its meaning over time. Using our common notions of kinds of regimes and kinds of constitutional orders, we will find it hard to adequately describe and explain the regime that is developing right in front of our eyes in Europe. Is it still a form of democracy? Is it a form of market dependence? Is it a bureaucracy or some other kind of mixed regime? We could do with some of Montesquieu's zeal in developing adequate classification of the regimes of the European Union and beyond, if you want to get a clearer grip on some of its structural problems that, incidentally, and that's the last comparison with Montesquieu, do threaten our liberty. Well, I hope my tale about Montesquieu and global law has been more than a little diversion and provided some food for thought. Certainly, the questions it raises are the kinds of questions that Professor Neil Walker has been writing lucidly about for many years now. Professor Walker is the Regius Professor of Public Law and the Law of Nature and Nations at the University of Edinburgh, a wonderful but challenging vocation. He has written many articles and edited a number of very important collections of essays on sovereignty, on constitutionalism, on the rule of law. Neil, we are very glad to have you in our midst again, for you know Tilburg well, and I'm going to give you the floor.
Thank you very much, Willem, and thank you to Tilburg Law School for inviting me. Thank you to the Dean, and thank you to the Law School in general, and also it's a great privilege for me to be here. As Willem said, I've been here on a number of occasions, going back at least a dozen years. I have some very close friends here, both in philosophy and in law. Hans Lindahl, Bert van Roemend, Hans Sonsen, a couple of people who used to be my students who have gone on to better things, Morag Goodwin, Daniel Augenstein. They were both my PhD students in Florence and are now working here in the law and in the philosophy departments. So it's wonderful for me to be here. I've always had some of my best intellectual times in this setting, and it's a place with treasured memories for me. It's also a great honour to be invited to deliver this particular lecture, especially at the time of the founding of the Global League, and also with the idea of the bachelor's degree, about which I'll have something to say in due course, something which is also on the horizon. Before I start, can I just say also to my Portuguese colleagues that I will not speak for any longer than 4 hours, which will allow you plenty of time to watch a football match, which the Dutch will not be remotely interested in. You think I'm joking? Okay. So let me start by saying something about the title of my lecture, Intimations of Global Law. In his writings, William Twining, who was one of my recent predecessors as a Montesquieu lecturer, has been endlessly fascinated with, and I think uniquely informative about, the processes and practices and the institutions and doctrines and the values which we might gather under the label global law. But he has always remained wary about the actual use of the term global law, or indeed any associated terms. So much so indeed that, as I'm sure he told you when he was here, he long cultivated the habit of banning the use of the G word in the lecture theatre and in the seminar room. For him, the term has at best limited added value. Indeed, it may even have a negative value, and this for two related reasons. First, he detects a tendency towards the exaggerated or the indiscriminate use, and also, therefore, the overuse of what remains a radically ambiguous label. Whether we're talking about a body of doctrine, a set of institutional capacities, a description of professional legal practice and culture, an academic discipline, a research program, a teaching paradigm, many are tempted to make vague or overstated claims about the prevalence of something called global law. The danger is not only that the general label global law will not add anything to our understanding of what is a richly disparate set of activities, but that it may even have a reductive effect. It might imply a false unity or a false coherence. Even worse, it may imply some kind of false normative ideal, one best way, one particular future vision for global law. In the second place, and this is Twining's second criticism, inasmuch as the global, more narrowly defined, might, as Twining accepts, more appropriately be taken to refer to events and developments on a worldwide scale, this in fact may be too narrow a perspective, where the first mentioned use of global law is too broad. So the first use is global law covering everything. The second use is global law as planetary law, expanding across the planet. And what Twining says about this second and narrower use is he thinks that it misses out much of what is most interesting about the intense contemporary movement of legal phenomena beyond the confines of the state. Instead, he wants to remind us much of this movement actually takes place at more limited subglobal levels, whether international, private, transnational, regional, or sub-state, and is far from being, to quote him, nested in a single vertical hierarchy in which the global level has pride of place at the authoritative top. Like anyone, I very much sympathise with William Twining's reservations, and I heed the warnings they contain. I particularly want to endorse his view that any consideration of the field of global law in the broadest and, in his view, the loosest sense should begin by concentrating on the inadequacy to new circumstances of global economic, cultural, technological, and institutional interdependence of the received model of the state-centred law world that is being left behind, rather than concentrating on the precise character of what is being put in its place or what might be coming in its place. It should therefore start from the increasing inappropriateness of viewing the state as a self-contained black box of legal doctrine, institutions, culture and education, rather than from any firm preconceptions of the shape of things emergent or to come. Nevertheless, in this lecture, I want to take a somewhat different tack, and I want to at least partially rehabilitate the idea of global law. It would be a bit of a damp squib if I didn't on this day of all days, but even if you weren't founding this league today, I promise this is what I would say. You know, rather than dismiss the use of the term global law for its analytical sloppiness or for its normative overreach, or indeed for its narrowness in concentrating on the global level, I want instead to ask what, if anything, we can learn from the increasing prevalence of the very invocation and application of the term global law in similar terms. In other words, I'm not so much concerned with the second-order utility or otherwise of global law as a concept, as a way of understanding or shaping the world. I'm more interested in its first-order significance as a term in increasingly regular circulation in the world that we want to make sense of. So global law may indeed not be a particularly helpful scientific or normative term, but nevertheless, it's a potentially interesting social fact that it is used with increasing frequency in the context of legal doctrine, practice, research, and teaching. So part of what I'm saying is that global law should be thought of not as an analytical tool, but as one way of describing, announcing a kind of paradigm shift within law, a movement towards a more global orientation. And that's going to be the focus of much of what I want to say. Even when the term global law is not expressly resorted to, we can observe in tandem with the growth in its explicit usage a heightened tendency to apply other terms for similar purposes and to similar effects, terms such as post-national law, etc., etc. In particular, global law and its cognates tend to be used in two interesting and to some extent overlapping ways, and I want to say something about both of them. Each, as we shall see, reflects one of Twining's concerns, but nonetheless may be deemed worthy of exploration. That exploration, as we shall also see, leads us to consider the intimated quality of global law, the other term in my title. By that route, I want to argue, we can gain some insight not only into some of the ways in which the legal academy is actually behaving in the face of transnational law, but also as to what kind of role we should expect and even encourage it to perform. So what then of the two uses of global law in regular circulation? And to some extent I've already anticipated these in my specification of Twining's criticisms. First of all, global law and similar generic or umbrella terms, such as post-national law or transnational law, broadly conceived, tend to be used as a holistic category. That is to say, they're used to observe and engage with the world beyond state law as somehow an encompassing object of reference, as in some sense a connected whole, rather than a mere aggregation or bundling of different phenomena. However reductive this may threaten to be from the standpoint of the scientific observer, arguably, as I said, is an important part of the lived experience, the gestalt of many who actively address or engage with the domain of global law. Now, obviously, if we are talking about professional practice or legal education and research, as in the various global law schools as centres which increasingly populate some of our most august institutions of learning worldwide, then that sense of connectedness, that integrity of the whole, is self-evidently aspirational. It's a matter of active construction and projection on the part of the practitioner. If we are talking about legal doctrine or institutions, on the other hand, the idea of a connected global whole, as we shall see in a moment, is a more elusive and a more controversial one, much less apparently within the constructive gift of the analyst or the observer, and much more prey to external forces. Nevertheless, this holistic approach to global law is one which increasingly informs, or at least implicitly frames the orientation of those thinking and arguing about law beyond the state. Okay? As I say, we're talking here about a kind of paradigm shift, and just even in terms of superficial evidence, we think about some of the new law journals we've had in recent years. We have the editor of Transnational Legal Theory sitting up the back. Even we have the editor of the German Law Journal, who happens to be the same person. And even though the German Law Journal, and I'll discuss why in questions later on, can be seen, I think, as a global law journal in the terms that I'm thinking about. And we can think about Global Constitutionalism, which is a new journal we started this year. There's a sense in which legal research and legal scholarship is self-consciously and reflexively resituating itself at the global level. Okay. Now, let's start to try explaining why this is happening and how this might be justified. And one of the ways I want to start by doing that is to revisit the other use of the term global law. So we have global law in the holistic sense, but we also have global law in the other sense, what we might call the globally extensive sense, where we're talking about global law as law which covers the entire planet, rather than law which covers everything within the planet. Okay? So let's call this globally extensive rather than globally holistic. In other words, it's a two-dimensional concept referring to activities aimed at the global level, rather than a three-dimensional concept referring to the world of transnational legal connections in its entirety. Now, to recall, this two-dimensional use is one that Twining approves of, though he wants to stress how limited it is as an aspect of the new state-decentered legal landscape. But again, if we stress the centrality of the perspective of the practitioner or of the actively engaged observer, the category of the globally extensive may be seen to assume a deeper significance. Once more, as with the category of the globally holistic, this point is more easily made about the more obviously practice-driven and aspirational world of the legal professions and legal education. Territorially unanchored and broadly networked legal firms or teaching or research institutions, such as a new law school's Global League, which we welcome to Tilburg this week, typically, well, I think it's unanchored unless Tilburg is going to be the centre of it, but assume it's a networked institution, typically make claim to globality as much, if not more, as a statement of their global expansive reach and presence and circulation, as they do as a measure of their commitment to treat global legality holistically. But with regard to the relatively hard data of legal doctrine, legal institutions, and legal orders, too, there has been a significant increase in claims which are situated at a global level. These claims come in a variety of forms, and I want to some of these forms overlap. Some are complementary, some are sometimes in some tension. And I want to say something about each of these different forms. This is where I should have overheads, but I don't. So what I want to do is I want to talk about various categories, various different ways of thinking about global law or law at the global level, which have developed in recent years. And I actually have 7 categories, but I'm not going to bore you by introducing them all at once. So I'll start with 3 categories which are distinguished by the fact that they're fairly hierarchical in nature, they're top-down, okay? So one category is a structural category, a second one is formal, and a third is what I call abstract normative. It's a kind of abstract normative category. And I want to say something about each of these. So each of these, as I say, embraces a hierarchical dimension, a sense of uniform direction in accordance with some kind of top-down authoritative mechanism, though not of the encompassing kind that we associate with state sovereignty. So by structural versions of global law, I simply mean those that emphasize peak institutions with strong legislative or executive capacity, typically the UN's charter and treaty bodies. By formal versions of global law, I refer to claims as to the lexical priority of global rules, as in notions of jus cogens or general principles of international law, or ideas of the exhaustive and non-negotiable reach of global rules, as encapsulated in customary international law or world order treaties or whatever. By abstract normative claims, I'm getting into maybe slightly less well-known territory. I mean those claims which refer to there being certain core ideas or a general normative template which guides, constrains, and is somehow present in more local iterations of law. So we sometimes find this within international human rights law, for example, and the discussion of the value and the function of the core international human rights treaties. Sometimes it's talked about in these terms, okay? So what we have here is a sort of sense of what I would call layered positivity, that you have the general level as a kind of deeper layer, and then you have the more specific surface local level. And sometimes we talk about international human rights law in these sorts of terms. But also there's all sorts of other, often theoretically quite experimental ideas, which have that same structure of layered positivity. So for example, Klaus Günther, a German scholar influenced by Habermas, talks about the idea of a universal code of legality, which underpins and informs specific laws. Matthias Kuhn, another German scholar, do we have a trend here? Talks about a general framework of cosmopolitan legal principles. Jeremy Waldron, not a German scholar, has recently talked about a new iteration of the older idea of a jus gentium, a law of the peoples, as a sort of general international law. Patrick Glenn, whom we've already heard of today, talks about some universal notion of the common law. He has this interesting idea that we always in the background have a notion of common law which complements our specific, particular positive law. Or even the bare idea of a global rule of law itself, which Rafael Domingo talks about in his new book on global law, or also Gianluigi Palombella has talked about recently in a number of articles. This idea as a global rule of law in which the supremacy of law as a means of conflict resolution is universally and unreservedly accepted. So what we observe in all of these and various other attempts is a kind of more penetrating excavation of the doctrinal surface of the law in search of some type of deep structure. So you start off with a particular law, but you don't just take the particular law, the particular local law at its face value. You then interpret it in terms of some sort of deeper code, in terms of this deeper abstract normative code. So all of these can be seen as attempts in their own very, very diverse ways to get at some notion of global law as a universal category. Then we can move on to other less hierarchical ways of thinking about global law at the global level. So the next category, the fourth category I want to mention, is what I call the historical discursive versions, which involve adapting older templates of state law to the global domain. The idea of global administrative law or global constitutionalism, or to take an example of a double adaptation of an older discourse, the constitutionalization of international law. So the emphasis here is on the mobility of certain principles and paradigms of law which are historically associated with certain disciplinary fields. Depending upon what is borrowed or how it is adopted, these approaches may be more or less hierarchical and more or less imposing of a uniform approach. For example, if global administrative law is seen as a set of principles which must apply to all situations of non-legislative or non-judicial transnational governance, say, duties to give reasons, to hear another party, etc., regardless of provenance, whether in private context, intergovernmental context, or in hybrid contexts, private and public, then it is to that extent hierarchical. Where more commonly global administrative law is merely seen as a toolbox available for utilisation depending upon highly variable government circumstances, then clearly a non-hierarchical logic of transfer is in play. Similarly, these same contrasting possibilities are available if we're talking about global constitutional law. In some cases, what may be emphasised is the adaptability to the transnational domain of the very pyramidal structure of state-centred constitutional law, including the idea of constitutional rules as a jurisdictional source and sort of a jurisgenerative capacity, or the idea of the higher or entrenched status of law. So Bardolph Fassbender's work on the UN treaty and charter system as a kind of constitutional structure for the world has that sort of intonation to it. Here, indeed, the idea of global constitutional law can merge with or support the structural or formal ideas of global hierarchy already considered. In other cases, however, this is interesting, what is emphasised is not the hierarchical dimension of constitutional law, but some trope or some principle which is concerned with the constraint of power, whether in terms of the separation of powers or the federal distribution of authority. For example, when Habermas talks about the constitutionalisation of international law, there being a regional level and a national level, but also a global UN level, what he's interested in more is the federal structure. So he's interested in that part of constitutional law which speaks to the division and the differentiation of power, the idea of federalism itself. So, and there's many other examples such as that. Other people talk about a cosmopolitan rights revolution. It's something which Alex Stone-Sweet talks about. Or again, the very basic idea of a global rule of law. All of these literatures are pointing in the direction of constitutional law as a way of actually imposing heterarchy rather than a way of imposing hierarchy. Now let's move on to a couple of remaining possibilities here. So briefly, the other three which I'm talking about are much more, whereas we've dealt with some which are hierarchical, some such as constitutional and administrative law, which are somewhere in between. I now want to say something about those models of global law which are more obviously heterarchical. They're not top-down, they're more bottom-up. So the next version I would talk about is what I would call the laterally integrative versions of global law. They depart quite unequivocally from the premise of plurality and heterarchy rather than unity and hierarchy. They include new iterations of conflicts of laws, much evolved from the state-centred model of private international law. In recent years, and I know some people here have been involved in this, there has been an attempt to rethink the idea of conflict of laws, not as simply a set of thin rules to resolve jurisdictional conflicts between states, but a set of thicker rules to resolve the much more frequent jurisdictional conflict between the many segmented orders that we find within the transnational field. And beyond that, there's other people who work within the pluralist literature who have developed ideas, not quite in the conflict of laws vernacular, but in something similar. So Miguel Maduro talks about contrapunctual law, when he's talking about the relationship between national law and European law. Nico Krish talks about interface norms when he's talking about the relationship between different global legal orders as well. So again, what we see in this post-national pluralist literature, which in many ways might be seen as anti-global, but it's actually not, because what it's trying to do is to try to find certain norms which act as some kind of coagulant, some kind of way of joining different national legal systems or different regional legal systems. Now let me finish with two final categories. One is what you might call functionally specific law, right? Where what you're talking about is the law of global segmented categories, where you're talking about functionally differentiated categories. Here, what you're talking about is a world of, unlike the laterally integrative models, you're talking about a world of presumptively unreconciled parts, more concerned with the internal structure of these parts than with the tissue connecting them. They include areas such as environmental law, the law relating to nuclear proliferation, and more contentiously, anti-terrorist law, where in an increasingly porous and interdependent world, the relevant public goods, or BADs, are non-excludable, and the global community provides a single community of risk. Other areas such as trade law, internet law, sports law, there are also specialist global regimes, here not so much because of the scale of the risk, but because of the intrinsically state-unbounded nature of the underlying practice. Finally, let me mention, as my seventh category, what I call certain hybrid forms of global law, where what we're concerned with are new ways of conceiving a global legal order from the fusion of old legal forms and sectors. I'll give you two examples. One is Ruti Taitel's idea of a new law of humanity, which claims to reflect, endorse, and encourage a profound normative shift in the international legal order from prioritizing state security to protecting human security. Cumulatively, the norms may be represented as a new law of humanity that spans the law of war, international human rights, and international criminal justice. So what she's saying is, put on a new pair of specs and see a category shift. Don't see these as being separate categories. See them as being part of a new single category, a law of humanity. Similarly, my Edinburgh colleague, Christine Bell, she talks about the notion of a new law of peace. The idea here is that the new state constitutional methods for negotiating peace in periods of transition, so-called transitional justice methods, interact with international law norms in areas such as criminal law, human rights law, and the law of humanitarian intervention. And they do so to create a new and dynamic mixed form which escapes the old discrete categories of intra- and transnational law while developing a genuinely global resonance. Okay? So earlier I said there was an important link between these various, what I call globally extensive claims, these 7 categories of law somehow occupying a global level, and the more ambitious claim of global law as an all-encompassing holistic perspective. Let me say something briefly at this stage about the nature of that link. Within our universe of legal thought, as we have seen in the above sketch, there are many candidates for occupying the global level. However, each in their different and not always mutually reconcilable ways purports to impose some kind of order out of the chaos of transnational law. This is most obvious and ambitious in the case of the hierarchical models, the formal, the structural, the abstract normative. But as we have seen, there are also various ideas of heterarchical order at work in this innovative catalogue. And this orientation towards order, it should be stressed, is one which contemplates and affects not only the law at the discrete global level itself, but also all the situationally intermediate forms of law which William Twining was at pains to stress should not be neglected. So these would include regional polities such as the EU, more limited economic unions such as NAFTA and Mercosur, other legal confederal arrangements such as the Nordic Union, regional human rights charters in Europe, America, Africa, and Asia, loosely imagined transnational but not global categories such as Commonwealth constitutionalism. They would also include a myriad of sub-state legal forms and of connections between these legal forms, from the EU's Committee of the Regions to the Council of Europe's Committee on Local Government, and the development as self-consciously mobile movements of various ideas of sub-state sovereignty or First Nation autonomy. Think of Evan Fox-Decent's work on trustee constitutionalism as a way of articulating the rights of First Nations. In some ways it's seen as paradigmatically local, but it's also transnational. It's an idea, it's a transnational notion of the local which is being used. Now, law as imagined and situated at a global level is never hermetically sealed off from this kaleidoscope of intermediate forms. Rather, it purports more or less modestly to frame and to contain, to create some kind of patterning which goes in the direction of a more holistic construction of global law. In other words, all the 7 categories which I talk about, they don't ignore these intermediate levels, they try to embrace and frame them within some more holistic idea. Okay, so I've got 3.5 hours left, right? And so I'm going to, I'll take a glass of water. Now I want to move on to the second part of my title, the notion of intimations of global law. Because what I want to do is, is I want to show how thinking of global law as an intimated category helps us make sense of this notion of holism which I'm talking about, and helps us make sense of the idea that global law is somehow a transformative paradigm in the way that we think about law. Okay, so why do I use the term intimations? I often think like this. I often come up with the title before I come up with the ideas. Therefore, you have to force your ideas into the box provided by the title. But it can be a useful thing to do. What I want to argue is that the way that we talk and think about global law or its functional equivalents as a distinctive category is in different ways tied up with its intimated quality. Okay? And one key consequence of this, as hopefully will emerge in due course, is that it not only signals a shift in the subject matter of the legal academic, the global legal academic, but it also signals a shift in the relationship of the global legal academic to his topic, to his or her topic. Okay? The very relationship of the legal academic to the very notion of law is changed as a result of this paradigm shift and as a result of its so-called intimated quality. So let's look at what I mean by intimated quality. The term intimation has a cluster of interesting connotations for us, each of which points towards certain common characteristics concerning what is global about global law. First, and most obviously, if something is merely intimated, it remains as yet unrealized. Okay? Something which is intimated is by definition not fully realized. Okay? Secondly, however, if something is intimated, then it already exists in embryonic or emergent form. So it's unrealized, but it's emergent. It's in the process of emerging. Yet, as a further connotation of intimation, this emergent form may only be hinted at or suggested, making itself known only indirectly. That is to say, its purpose and meaning remains oblique, contingent upon our creative insider endorsement or interpretation of some external evidence. So it's unrealized, it's emergent, but it's also recondite or oblique. It's not something which easily expresses itself. We have to add our interpretation to it. Finally, if more rarely, although it is quite commonly known in legal English, we use the term intimation to convey the idea of advance notice of something which is predestined or at least unavoidable. This indeed is a meaning which is deepened and rendered familiar by its literary resonance. When William Wordsworth wrote his famous Intimations of Immortality in 1802, and when a much later and much less romantic figure, the American Beat Generation poet Allen Ginsberg, wrote his Intimations of Mortality in critical homage to his much admired predecessor, both were agreed on at least one thing. By invoking the term intimation, they were referring to the relay and the receipt of an advanced signal of something considered as beyond their control, as a matter of fate, as something inexorable. So by intimation, we mean four interestingly connected things. Something which is unrealized, yet emergent. Something which is oblique, yet inexorable. Why and how does this cluster of characteristics capture something importantly distinctive about global law and about the role of the legal academic before global law? Well, for the rest of the lecture, I'll try to explain. So let's take these characteristics in pairs, starting with the unrealized yet emergent quality of global law. So first of all, discussion of global law are of an entity or a practice typically unrealized or unfulfilled and so future-orientated. No longer embedded in the state, the authority of global forms of law is uncertainly and insecurely located. It is what I've called elsewhere uncharted law, not yet registered on any of our established maps of legal authority. Global law, as we saw above in our discussion of its various applications as an extensive concept, often makes reference to law's heritage, sometimes strong reference. But global law does not exhibit the traditional structure of most modern law. It does not involve the three features of, first, an orientation towards contemplation of past legal processes and events. Secondly, the selective specification of that past as an authoritative present. And thirdly, the conduct of that selected specification in accordance with a recognised transmission procedure, which consciously ensures continuity between past and present. These, as Martin Regius has reminded us, are the traditional structure of modern law. They typically figure as central features of any modern state-based or indeed any jurisdiction-specific legal system's generic claim to authority. This traditional structure is present where a law's authority is based upon case precedent, or custom, or code, or legislative or constitutional history, or indeed some combination of all of these. On the other hand, whenever some species of global law signals back to an existing discursive code of legal authority, whether, say, global constitutional law, or global administrative law, or global human rights law, we can be sure that whatever combination of inspiration and legitimacy is sought by reference to the past, the kind of strong internal link between tradition and authority that Regius indicates is not being made. That is to say, there's no deep path-dependent general authority available to provide systemic undergirding for this particular new case. So the case for any particular version of global law tends to have to justify both the species and the genus, both the particular instance and the general category. So whether we're talking about global administrative law or global constitutional law, the sorts of particular claims that are being made are simultaneously trying to justify the general category itself. And that's something which is different from the traditional structure of modern law. So secondly, the fluidly emergent quality of global law reflects and reinforces the fact not only that the authority of any particular species of global law is uncertain, but also that the authority claims of different emergent trends tend to clash. The problem of the uncertain authority of new global legal orders, therefore, is compounded by the very diversity of such orders. Indeed, again to quote something that Pearson Banson talks about, there's an ironic circularity, or perhaps a vicious spiral at work here. The very proliferation of new global or post-national ways of thinking about and conceiving of legal authority, is itself in part a function of legitimacy anxiety associated with the unsettled authority claims of old and new species of law. Yet, the circularity lies in the fact that this proliferation and the multiplication of competitive overlaps between different legal orders that it yields merely amplifies existing difficulties. All this is all the more so because of the tendency of the various claims discussed above, the structural, the formal, the abstract normative, and the historical discursive in particular, but also, if more modestly, the laterally integrative, the functionally specialist, etc., the tendency to try to operate as kinds of meta-principles of legal authority. And what I mean by that is that these ideas, they try to help frame and resolve the relationship between the different and overlapping sites of legal ordering in a post-national world in which the old default meta-principle, the Westphalian meta-principle of state sovereignty, is no longer available. Instead, we have part of the proliferation of the new forms of global law has to do with the fact that people aren't just looking for new ways of regulating the world, they're looking for new ways of regulating the relationship between the different legal orders within the world. This absence of an agreed meta-principle of authority or order of legal orders leads to what I've called the disorder of legal orders, the lack of an agreed ordering relationship between legal orders. Then, despite and indeed because there are so many candidates for the role, this lack of an agreed relationship is a key defining feature of global law. It's both a circumstance that frames much activity and a reinforced consequence of that activity. So, it should already begin to become apparent how this new horizon of global law affects the relationship of the legal academic to his or her subject matter. The unrealised yet emergent quality of global law alters a balance between the embedded and the aspirational dimensions of law's normativity. Global law lacks the past-orientated authority of state-based law and encourages a competition between new horizons of justification. Legal order, and even the relationship between legal orders, becomes somewhat more a question of projection and construction, and somewhat less one of retrospection and endorsement. And in that process of projection and construction, the emphasis shifts from custodianship of a state-based legal tradition to the creative reworking of old forms in search of the new. Such an orientation prioritizes future over past, reframing over frame filling, creativity over conformity, paradigm shifting rather than paradigmatic authority. And in these circumstances, legal scholars inevitably become less the relatively minor keepers of a tradition and the more significant refiners of its doctrine, and they more become a special case of what Robert Reich has referred to as symbolic analysts. And he uses that term to refer to a new breed of social thinker for the modern age, or the late modern age. Those who both comprehend and express the power of new problem definitions and new framing ideas, think of my 7 categories, to harness the social technologies, including law, capable of achieving collectively desirable ends in circumstances where the appropriate constituency and plausible means of collective action become ever less clear. It's against this background that we can understand the prominent role of the legal academy in initiatives such as the global recasting of constitutional and administrative law, the new hybrid legal forms of the law of peace or the law of humanity, and the development of new principles of lateral integration, not to mention the recovery of more hierarchical models of coherence. Brief interlude before I move to my conclusion. Just a word on Montesquieu, which has probably been made redundant by the earlier discussion. But the merest glance at the life of the 18th century Baron de Montesquieu, whom we honour in this lecture, reminds us that there is nothing entirely new under the sun, and so counsels us against exaggerating the claim just made. Montesquieu, as you know, was an early comparativist, perhaps the father of comparative law. As such, he was someone who already understood the vital lesson that law's legitimacy was not something which could be sealed off and preserved in history or in geography, but which, with due and insistent acknowledgement of the continuing power of place and of embedded culture to affect what we consider appropriate and desirable, nevertheless demanded the exchange of ideas of good practice and the adaptation of institutions to new circumstances. His fascination with elsewhere was based upon a new modernist awareness of and respect for the practices and experiences of others, a rationalist conviction, equally modernist, that we could learn from such experience, and a post-metaphysical sense, also modernist, that not only could law be adapted to new circumstances, but that it continually required to be, that its legitimacy was not timeless. Montesquieu, in other words, already saw the need for a healthy balance between tradition and innovation in law. Yet such was his perspicacity that I have no doubt that, if he was alive today, he would see more clearly than any of us how the fluidity of the new global landscape has shifted the balance still further towards the need to think of law's appropriateness and legitimacy in more contingent and provisional terms, rather than as a settled or local accomplishment. So his horizon was not our horizon, but it was a horizon which already anticipated something of our horizon. So let's now move on to the last 2 aspects of global law as an intimated object. And let's, through this, try to gain a little bit of additional insight into the shifting role of the legal academic within the new paradigm of global law. First, there's what I call the obliqueness of the evidence of global law, the fact that it doesn't announce itself often as global law, and so we have to do a lot of interpretive work, the need for constructive interpretation and endorsement. What this speaks to is the other side of the coin of what we considered above. It refers to the continuing significance of the constraining alongside the creative aspect of the horizon of global law, the given alongside the negotiable. In the founding editorial of the new journal Global Constitutionalism, which was published a few months ago, for example, we see repeated insistence on the so-called double nature of the project, as one of mapping as well as shaping new constitution-like global norms and institutions. The point here is a simple but important one. If the global legal landscape is an unprecedentedly fluid one, then this makes it more rather than less important to start with a good understanding of what is happening out there. It is incumbent upon us first to document the many shifting trends of transnational law precisely and insightfully. It is indeed remarkable, if you think about it, how much of the new global scholarship is about trend spotting. Trend spotting is really trendy. Whether we're talking about the growth of proportionality analysis, or of experimental governments, or of administrative law type procedures, or of nudging and smart sanctions, or rights mainstreaming. I could go on for days with the examples. But what you see in this new global scholarship is an attempt to look at trends, to find trends, to discover trends. Because the law is not safely encapsulated within certain time-honoured categories, there's a new premium for discovering where the law is going, what the main movements actually are. Both the plausibility and to some extent the legitimacy of what is proposed in the shaping phase depends crucially upon what is discovered in the ever-shifting mapping stage. What is oblique and circumspect must first be rendered transparent before it can be guided and reshaped in real time. The image of rebuilding the ship at sea has become popular in legal and policy circles in recent years as a way of expressing the difficulties of grounding a continuous process of reform. Indeed, it's the title of a well-known legal and political analysis of the post-Berlin Wall constitutional transformation of Eastern Europe. With global law, we go a stage further. The seafarers of global law arguably have an even more difficult task, a multitask indeed. They not only have to rebuild the floating ship, but they have to do so in a shifting sea whose nautical charts they must also constantly revise. A different level of activity. Finally, there is what I call the inexorable quality of global law. And I think this reinforces the significance of global law as a holistic category. The reason why many legal analysts tend to think of global law in the round as a holistic category is not just due to the ways in which its unrealized, emergent and oblique qualities mark it out as a distinctive paradigm of critical and constructive thought, but it's also more generally because of the ways in which the category of the global has insinuated itself into our everyday social imaginaries. Manfred Steger has written about this in his book, The Rise of the Global Imaginary. He says that we increasingly take for granted a global horizon of cultural and political possibility alongside our national and other frames of reference. The dissemination and widespread cultural embedding of different global themes, both utopian and dystopian, both exotic and mundane, from global justice, including contemporary political themes and movements such as feminism, environmentalism, and nuclear disarmament, which were born in global rather than national political spaces, but also to global jihad or climate change, from the marketplace, the global marketplace, to the Football World Cup, whatever. It means that thinking globally takes on both a headline significance, but also an everyday, a quotidian, a common sense significance. Indeed, it can become so taken for granted and so natural to think globally in certain legal and political areas that we can lose sight of how far and how quickly our orientation has changed. I was speaking to the student editors of the Tilburg Law Review this morning and making this point, saying that if we, to the extent that one lives with the change, you don't see it. The kinds of horizons I had starting off as a legal scholar over 30 years ago are very, very different from the kinds of horizons I have now. And I would be shocked if I revisited my earlier self, I'm sure of it. I'd be shocked in all sorts of ways, but in that way in particular. So the inexorability of global law, moreover, is not just a function of its multiform prevalence, but also of a deep accompanying assumption that globality is a phase or an age whose inevitability and irreversibility in principle is as certain as its detailed trajectory is unclear. Lawyers, like many others, are faced with a terrain as inescapable as it is inscrutable. This indeed is why we hear so much talk of the post-national, but very little of the post-global. We may argue and struggle over how far the interconnected global age has come about and should proceed, and indeed over whether various bits and pieces can be reversed, but the idea of a full-scale retreat to a state-centred paradigm of law seems as unlikely as putting the genie back in the bottle. So let me conclude just with one thought. The new global law is one whose holistic form captures and expresses what is nothing less than a shift in the legal analyst's relationship to law itself. The hard work of doctrinal analysis will, of course, remain central to much law teaching and research, but alongside this, the global lawyer, as symbolic analyst, is becoming and must become more adept at trend spotting, more engaged in challenging or rethinking our very ideas of legal order, more reflexively aware of the role of the legal analyst herself in the mapping and making of legal authority, and more reconciled to this new world as a steady state of unsteady post-national authority. Interesting times ahead. Thank you.
Neil, thank you very much for a very interesting presentation. And even while it was abstract, it was also very clear. I think you told us that there are at least 7 ways of extending global law, and that all of them have some potential of creating order into the chaos of transnational law, but also saying that these are intimations of global law. And then you had this great formula of unrealized yet emergent, oblique yet inexorable. And we should remember that, because it's a good formula that we might be able to ask questions about. We do have some time for questions. And I think that Murak Goodwill will be walking around with a microphone so that your questions can be amplified and heard here at stage. And since I know that moving from a listening mode to a more active interactional mode is quite a change.
You'll ask the first question.
I'll ask the first question. And I was hoping I would have that privilege. And in fact, I have a question about both parts of your talk. First of all, about the extensions of global law. And from a perspective of Montesquieu, again, you could ask actually of all of them, what kind of quality of life, quality of the political order, of the quality of the rule of law would be possible if you start doing that? Does it affect the life of people? Or is it something, an analytical tool that we need in order to understand what kind of world we're living in? That would be, how does it translate on the ground, basically, for people who are living, for instance, in a laterally integrative kind of legal system? And for the second part, I would have another question, maybe a little more technical, but there you say that global law is not working in the way Martin Krieger describes traditions to work. And how do you think about Patrick Glenn's approach to tradition, who says, well, maybe we should start conceiving of tradition as one large discourse, and as long as the discourse is going on, maybe not in a hierarchical way, but in a more lateral way, I still call it a tradition. And then maybe your intimations would be the indication that the tradition is very much alive, because without any debate and interpretations, there couldn't be those intimations at all.
Can I start with the second one, because it's probably I was going to say it's easier, but it's slightly less difficult.
They're both very easy.
Both simple. Thank you. I actually had this discussion with Patrick Glenn about this, and one distinction which I offered him was between traditionality and traditionalism. So traditionalism or tradition is just the very way in which we think about, honour, and give value to the past, often unreflexively. Traditionality is an odd thing, because it's something which affects law, affects some other things, but it's actually a reflexive use of tradition, right? So you reflexively, consciously think about traditions, and you work them into certain practices in a very, very productive way. And my sense was that much of law has different types of traditional structure, but there's something about modern law which has a kind of reflexive traditionality, which is very, very much something which is distinctive to it. Now, global law, and let's not exaggerate, much of global law is about the further iteration of modern forms of state-based law. Of course it is. But we're talking about things which go beyond that. As it goes beyond that, I think, you're more likely to come into the world of speculative recreation of law's authority claims. Now, there's a point at which that itself may well be traditionalized, right? I can imagine it could be traditionalized. And you might say that global administrative law, global constitutional law are themselves extensions of existing traditions. I think they are extensions of existing traditions, but I think that, the kind of use of traditionality as a way of rendering authority automatic isn't working in the same way within these global methods, these global modes. Your first question, of course, I mean, much of global literature starts from this idea of the increasing impenetrability of law, the fact that people now exist in relation to many different legal systems simultaneously. I mean, I would always want to differentiate between very specific normative anxieties that you might have about that, about precision, knowledge of rights, democracy, voice, etc., and some kind of what I think is a fake sense, and I'm not accusing you of this, that somehow there was a golden age where people knew what their legal sources were, and and people always knew what the basis of the legal order was, etc., and somehow that's gone with globalization. I think there is something interesting about Peter Linseth, for example, a administrative lawyer who's written interestingly about Europe, actually talks about people's sense of the legibility of law being quite important to their understanding of it. And there is something in that. But to me, that's more important as indicative of other objective things that we should be concerned about, the loss of rights or the loss of democracy. So I would rather treat it as a kind of detailed balance sheet rather than something which involves, almost categorically a kind of profound dissolution of the very idea of the rule of law, because I think that overstates it.
Yeah. Okay, well, thank you very much. I see that this hall is literally packed with people who know much more about global law than me. So at least one of you must now have this kind of opportunity to ask the burning question to Neil, and grab your opportunity and ask it. Yes. You need a microphone.
Thank you. I'm Vlad Perju from Boston College Law School. I have two quick questions. The first one is, you didn't mention human nature. And all accounts of social ordering through law in history of political thought, in one way or another, had some sort of a theory of human nature. And I wonder if that's something that comes up as you think about global law. And the second one is, again, at the very abstract general level, in the history of thought, periods of simplicity are followed by periods of complexity. There are moments where advances in thought come through discovering ever greater complexity, and moments when advances in thought come through discovering ever greater simplicity.
Give me an example.
Leibniz is an example of ever greater simplicity. Now, the story that you portray of global law is one that is incredibly complex. So my question is, what do you think the future is, the future of global law, if that future implies in one way or another any kind of process of simplification? So what will be filtered out? What will stay in? Can we tell? What would it depend on?
Okay. Right. Well, first of all, I don't necessarily accept your premise that we move from complexity to simplification. But the question, even if I weren't to accept that premise, the question remains. I'll come back to human nature in a moment. I guess part of it has to do with our understanding of the very way in which Okay, I think one of the particular features of modern law is its jurisdictional specificity. Okay, so which usually means less abstractly that it's state-based. But so what we're used to, the Chalcedonian order, the practical syllogism, the way in which particular authority depends upon the Stufenbauer, the chain of authority going all the way up from the particular to the general authority. And that's a very modern way of thinking about law. And one of the things I'm doing here is imposing that modern paradigm on the kind of problematique of postmodern or post-national law. I'm saying that part of the problem is that people are, in these new contested post-national spaces, people are trying to resolve the question of the right answer. Not just by coming out with the right answer, but by saying, this is the right answer because as an example of how I would resolve the overall question of the map of legal authority. Right? Now, that raises a very interesting question about whether that very double-order categorization will itself survive the new forms. I don't know the answer to that. I think a lot of people would quite strongly say it doesn't. But the answer to that isn't yes or no, because within the post-national order is one which also still incorporates the national order, and there's lots of the old stuff, which is still going there as well. In terms of human nature, very quickly, I would say that most historical theories of law don't necessarily have a vision of human nature. They've certainly got a vision of political man. They certainly have a vision of what is the nature of the political and what's the nature of the political community. And I think that's something which is, which I think was also implicit in your question, that the black box theory of the state, of the state as a kind of exhaustive framework, for the resolution of the political, which itself is a product of a modern way of thinking, which is based upon the equality and autonomy of individuals. And the way to resolve that equality and autonomy is to do so within a particular exhaustive political community. My sense is that there's always been a tension within modern law between the particular and the universal, because the very discovery of individual autonomy and equality, the very discovery of the modern idea that the world was a project for us to make over in our own terms, rather than conforming with some external order of things, is something which is both very particularizing and very generalizing. The state was always a difficult compromise. The work I've done in constitutionalism shows this, the sense that, a lot of people announce the beginning of the national constitutional project as a very strong particularizing move. It's not. It's both a particularizing move and a universalizing move simultaneously. It's both saying that's how we will order our political community, and sotto voce, that's how the world should order all its political communities. So moving away from the state model isn't necessarily moving away from that notion of the equality and autonomy of individuals.
Okay, thank you. I see some reaction in the back, Murak.
Thank you very much for a wonderful lecture. I would like to actually sharpen Professor Perdew's second question a little more, because I think it's really quite important. So even if we won't go to a less complex and layered narrative after this period now, the question is who will take charge of that process? So the more differentiated our analysis becomes, and the more obvious, for example, for law teachers it is that we have to expose our students to political science and sociological accounts of what's happening right now. And even if we don't, go very fully into an investigation of human nature, but we now know that we study the World Bank's behavior through anthropological research, for example, because we can't just operate with either critical or whatever universalist conceptions of human rights. The thing that has happened when the state demised is that the scholars that were very sophisticated in developing legal theory after a welfare state, they were highly tolerant and worldly in their approaches, but the law and society movement that followed the demise of the welfare state was law and economics. And so that was a very simple and rough approach to make sense of our complex world, where the vulnerabilities and precariousness of life was just getting stronger. So and it's really difficult for us to ask that question because we don't even know where to start to look for answers. But for example, if David Harvey were here, he would say, well, can't you see who's taking charge now? So whether that's simple or complex, so that's really the issue. So whose agency is going to take charge here?
Who said that life was easy? Huh? This is a big one.
I thought if I name-checked him 3 times, you wouldn't ask me a difficult question. It depends what you mean by taking charge. You know, I mean, I think I misconstrued your question because at first I thought you were asking the question of who steers the overall ship, and to some extent you are, but you're not asking that question necessarily about the law. You're asking that question about the world. You're not. It's the, and of course the what is always missing in these kinds of law-centered analyses, you know, is what is the nature of the shorthand globalizing world, which is actually, you know, been subject to these complex types of transnational legal moves. And of course, many people would say there is a crude simplicity to that. You know, that actually, you know, the global law and global institutionalization of politics more generally, you know, is really a response to an unprecedentedly singular type of control of the world in terms of a global neoliberal economy or whatever it might be. Okay, and of course, global law then is both, you know, it's the solution and the problem, you know, because often it is an expression of the very forms of power which, in other iterations, it might be challenging. You know, it's, for example, we were talking earlier about a recent piece which appeared in your journal, the Transnational Legal Theory by Horatia Muir-Watt, which was talking about the way in which private international law, historically, by its silences, allowed, or in a sense refused to interfere with transnational economic activity. You know, it both said that is the domain of private law rather than public law, but as a domain of private law, we as private international law are not concerned to do anything other than be the most basic umpires at this game in terms of choice of law rules. So by its absences, law can often reinforce these things, but also by its presences, it can challenge them. So thank you, because what you've done is that you've reframed the problem. The problem is a problem of the world. It's not a problem of law. And but and there is a sense in which I guess and this is generally true of globalization. Globalization contains both the fantasy of new forms of control and the recognition of new forms of failure of control. You know, the fantasy of new forms of control, whether it be humanitarian intervention, etc., is precisely about the availability of global juridical forms, which just have not been available historically, tied to military power, etc., to achieve certain ends. But you know, but global law in the face of the power of certain forms of global capitalism is also a peculiarly disempowered form of law. So that isn't an answer. It's just to say that global law is both uniquely empowered before the world, but I think also in some ways uniquely disempowered.
Pierre Larouche, Professor of Competition Law here in this faculty. In your speech at some point, I saw you alluded to the fact that with global law, you introduced some distance between the legal scholar and the national system. And I like that idea very much, but I thought it wasn't pursued further. And I would like to just try to pursue it further and give a proposition at the end. I thought the examples of global law that you gave, often if you look at global administrative law, global constitutional law, in a way, it's an attempt to replicate at global level the structures that we're familiar with at national level. It's a set of rules, it's hierarchical, it's consistent. But if you are allowed to take distance from that model, not just take distance from national authority, but also take distance from the model of a legal system,
Sure.
you could argue the object of global legal scholarship is not so much a positive order or hierarchical order, it's just the realm of possibilities that exist for the designing of law across the world.
Yeah.
And so if I stick to the traditional or the understanding of global law that you had in your discourse, the question would arise, couldn't you perhaps have global legal scholarship without necessarily having global law in the sense of the structure that we're used to?
Yeah, you could, and you do. You know, I mean, I think that's why I probably didn't make it clear. You know, I said, look, you know, even if, you know, if you go back to take a journal like Global Jurist, which started, when did it start? 10, 15 years ago. Interestingly, if you look at its design and if you look at its mandate, it very much talks about comparative law, right? And so it's basically, in some ways, quite old-fashioned. You know, it's saying that you know, we can learn from and also learn what is distinctive about us by looking at other legal orders. We can also, you know, maybe do something eclectic or whatever by looking at other legal orders to try and plan and develop transnational legal orders. But there isn't the same insistence, which I even see more recently in the designing framework of that model, that what we're dealing with is something which is palpable, something which is emergent, not just that it's not just an academic exercise, it's not just a theoretical exercise. So I think that an awful lot of what is global law is okay, two distinctions. One is, if you think of global law as a body of law, ontologically something we call law, right? Okay, I think it's more emergent, less complete, more contested, less settled than than national law. If you think of global legal scholarship, then it's not just the study of that. It's also the study of all other things which are relevant to transnational law. You know, so if Barak was here, you know, he'd be talking about this. He'd probably be quite happy with the language of global law, but he'd be talking about the transnational migration of ideas between judges, etc., which is all important as well, and which is one of the kind of minor premises of global law. So yes, it can be much broader than that, but I guess what I'm saying is a good question. At least part of what we do in global law has to be an investigation of this difficult stuff that I'm talking about, you know, the globally extensive law and the way in which it relates to national law. I don't think we can. Sometimes when I hear a certain type of constitutional comparative scholarship, I think it inhabits a comfort zone that I don't recognise. It treats globalisation as the way things are, with a little bit more porosity, you know, with a little bit more interchange between judges, a little bit more migration of constitutional ideas. And I think that understates what is going on there. So global law as a project has to include, but it has to be more than comparative law. Does that answer your question?
Kind of. I mean, I meant also more than comparative law in the sense
Yes.
that you just don't lay all the systems next to one another. You try to see, I just don't see why global law needs to have a answer or a solution.
No.
To me, it's the study of the range of possible answers,
Yes.
the range of choices. And
Yeah.
that range is not infinite. It's smaller than the number of jurisdictions.
It's a
sure. That's what you want to know. What is out there?
Yeah, it's a study of the range of choices, but it's a study it's a study in practical reason as well, because it's something which has to, it cannot be indifferent to the question of what the better choices are and what the worst choices are, you know. And I mean, earlier I mentioned the German Law Journal, this idea that why I thought it was a global law journal. Of course, one of the reasons I think it's a global law journal, and it's not the only one, is that I think, and this may be a question for your Tilburg's bachelor's program, you know, that one of the things that struck me about it, I remember at first thinking, why is it that a German law journal is so interesting to people who are not particularly interested in German scholarship? And of course, the reason is is that probably about 70% of it isn't really very much about domestic German law at all. But it's about law which would be relevant to any German scholar who was remotely interested in the interdependence between a national legal system and the rest of the world's legal orders, whether it be the ECHR, the EU, the UN, or whatever. And that's the interesting thing, because there what you get is an example of saying that if you're a globally aware scholar, then you still need at some level to be embedded within a particular legal order. But that becomes the beginning of your orientation. Now, it doesn't embrace your orientation. It's maybe, whereas at one point it was maybe 70-80% of what you could be interested in, nowadays that would just not be the case. Now, that doesn't mean that every law degree or every law qualification will be like that, but I think something like the German Law Journal or other examples are very indicative of the way in which scholarship as a whole is much more of a continuum between the national and the post-national than once it was.
Let me see if there are any other burning questions or whether we are reaching the end of this marathon. Hopefully with everybody still in place and able to reach the barbecue, which would be a great purpose to...
Even the Portuguese, yeah.
To get Well, if that seems to be the case, I don't see people jumping up because they want to have the microphone. Okay. Let me repeat again that this was a very interesting afternoon. We hope to produce a small booklet out of this lecture as well. We have been doing so already with the lectures by Twining and Barak. And if these are topics that profoundly interest you, there is a possibility to obtain a free copy of these books. So do not let that opportunity pass you by. And let me end by also endorsing the German Law Review. Pierre was so friendly to put me on the subscription list last year, and I have thoroughly enjoyed many of the articles in this journal. And it's available on the internet, also again, not with much cost. So maybe one of the aspects of global law that interests me a lot is that a lot of activity and a lot of information is being generated in all kinds of places, being available to all kinds of people and stimulating the meeting of minds in all kinds of settings that are outside of the ordinary institutional formats. And maybe that is also a shape of global law that we should cherish and develop. And perhaps even this League of Global Law Schools might contribute something to that purpose. So in that way, we can more or less conclude where we started with a celebration of this meeting, where people are together to think and work about the way global legal education and research can be pursued. I hope to talk to many of you tomorrow. As we all do, I'm going to thank Neil for an entertaining and interesting and stimulating afternoon. Thank you very much.
Thank you.
Neil, I've been tasked by presenting you this small gift. It's I'm not going to say what it is. It seems to be something typically Dutch.
Right.
You get it from a Belgian. So you can feel like a foreigner receiving a bottle of scotch by an Englishman in Scotland.
Okay.